All right. Good evening once again. I believe we are doing good. So we continue from chapter 3 today. We can go and read chapter 2 on our own. I don't think we have actually dealt with that. So, and the chapter 2, the topic we have before us is objection and appeal procedures. Objections and appeal procedure. Um, when we file our tax, at times there may be disagreement between the tax we are asked to pay and the tax. Okay, there may be disagreement between the taxpayer and the tax authority. So there are some laid down procedures the taxpayer can actually follow in filing or in objecting to the stand of the tax authority. So after you have paid your tax and the tax authority says, no, that's not the amount you are expected to pay. This is the amount you are expected to pay. Then, once there is a disagreement like that, a wise taxpayer, instead of dragging it, we actually try to appeal just to be able to uh, get appropriate justification. So today we'll be talking about the objection and appeal procedure. I will have actually skip all these chapters and go to calculation chapter. But I get to know that question can come from any angle. So there is a need for us to actually understand all these theoretical aspects of taxation. So now we'll move to 3.2 element of valid objection and appeal procedures. Before you can actually say that I want to appeal because the tax authority is actually giving me what they're supposed not to give to me. What are the procedure? What are element of valid objection? Before your objection can be a valid one, what are those things you must do? The A, timely submission. The objection must be submitted within the stipulated time frame, 30 days, to be considered valid. Before your objection can actually be considered valid, it must be submitted within 30 days. 30 days. That is where you file your return and when you are making the appeal, it must be between 30 days. Maybe the tax authority serve you your tax liability and you are not clear with it or you are not satisfied with it, you must file your objection between that day and 30 days. Anything outside that day, after they have actually served you with the tax liability you're expected to pay, you you are not going to be considered as a valid. It is not going to be considered as a valid objection again. All right. The second is it must contain clear grounds for objection. Why are you objecting this particular liability they have given to you? It must contain clear grounds for objection. The objection must specify in details the ground upon which it is made, including fact and reason for objecting for each issue. Completed objection form is number 3. You must complete what? Prescribed objection form, which are varied depending on the type of tax under consideration. Supporting documents. Before they can consider your objection as valid, you must attach evidence. You must attach supporting document that shows that you are actually on the right path. You are actually to be justified. Supporting documents. So you must support your document or objection with appropriate document. And the E part, payment of non-disputable tax. Payment of non-disputable tax. The taxpayer must pay all tax not in dispute, as well as 50% of the amount of tax in dispute for value-added tax objection. So you must not be owing tax authority as at the time in which you are filing objection. If your objection is going to be considered valid, you must not be owing any tax. And also, if you are actually objecting value added tax, you must pay 50% of the amount that they are actually that you are actually in dispute of. You must pay 50% of it. Then we move to time limit for objection and appeal. Time limit for objection and appeal. In Nigeria system, the time limit for objection and appeal are as follows. A, notice of objection. As we have said the other time, the taxpayer has 30 days from the date of receiving the tax assessment to file a notice of, excuse me, notice of objection. If don't forget that 30 days, 30 days, you must what? You must file your appeal within 30 days. After you have received your tax assessment or the tax liability that you have been asked to pay by the taxpayer, by the tax authority rather, you must make sure that you file if you are in dispute with whatever assessment they have given to you, then uh, you must file an objection within 30 days. B. Appeal to the tax appeal authority. So that is the first stage. That is the first stage. Appeal to the tax appeal authority. That is tax. If the taxpayer is dissatisfied with the response to their objection, they can appeal to the tax within 30 days of receiving the notice of refusal to amend. So that is the first level you can actually go to if you are dissatisfied with the assessment that is being given to you by the tax authority. Then the next one is appeal to Federal High Court. If a party is aggrieved by the final decision of the tax, they can appeal to the Federal High Court within 30 days of receiving the tax decision. So if the appeal if the tax appeal authority now give their decision and you are still dissatisfied with the decision that the tax appeal authority has given, then you can move to appeal. You can move your application or objection to the Federal High Court, and that also must be within 30 days. Within 30 days, if you are not satisfied with the decision of the tax appeal authority. Don't forget the first place you need to go if you are dissatisfied with the assessment that is you are being served is what? Is the tax appeal authority. Then if you are disagree, if you are not satisfied with the final decision that is being made by tax appeal authority, then you can move to Federal High Court. It is essential to note that these limits are crucial, and failure to adhere to them results in the assessment becoming final and conclusive. Becoming final and conclusive. Then content of the notice of objection. So the notice of objection now, what are the contents? What are those elements? What are those things that must be included in the notice of objection? We have the tax file number. Tax file number that we also call tax identification number. You must include it. The relevant year of assessment, that is that particular year of assessment that you are in dispute of, you must what? You must include it. The date the notice for refusal to amend was received. The date the notice for refusal to amend was received. This notice for refusal, it actually means, okay, the tax authority, they actually serve you a particular assessment, then you write to them, appeal to them that no, this thing you have said is not really it because of this, because of this, because of this. Then they now send you a notice of another letter in response to the application letter or application letter you have sent to them. They now respond to that no, we are not going to reduce your tax or assessment by any percentage. This is the amount you should pay. That is notice of refusal to amend. So you must what? You must put the date the notice of refusal to amend was received. Then the assessable profit for the year of assessment being disputed. You must also include the assessable profit of the year of assessment being disputed, the taxable or total profit being disputed, the amount of tax payable disputed, the grant of appeal. Note that grant of appeal may not be different from the grant of objection. Then we move to amendment of assessment and refusal to amend, amendment of assessments, and refusal to amend. Upon the receipt of the valid notice of objection, the relevant tax authority will examine the grant of objection to determine its validity. Where the grant are found to be valid, the tax computation will be reviewed and a revised or amended assessment raised. Payment would be based on the revised amendment within the statutory time limit of 60 days from the date of receipt of the revised assessment by the taxpayer. In the situation whereby there is a what? There is an amendment to the tax you are expected to pay. Then you must make sure that you pay you make the right payment within the 60 days after the amendment has been made. B. Where the relevant tax authority believes that there is no merit in the notice of objection, then a notice of refusal to amend (NORA) will be sent to the taxpayer, and I've explained the meaning of the notice of refusal to amend. C. The taxpayer, if aggrieved by the notice of refusal to amend, will file a notice of appeal to the Tax Appeal Tribunal within 30 days of the receipt of the notice of refusal to amend. Are we together? Are we together?
Yes, sir, we are together, sir.
All right. This is just the
Yes,
revision of
sir.
what you have. This is just the revision of what you have learned in in 8 years. Yes, in 8 years, even during the school days. All right. Appeal procedure, appeal procedures and processes. Tax Appeal Tribunal. So the tax now. The Tax Appeal Tribunal was established by Section 59 Sub 1 of the Federal Inland Revenue Service Establishment Act 2007 as provided in the fifth schedule to the Act. The Tax Appeal Tribunal Tax is an administrative body established by the Federal Inland Revenue Services Establishment Act to hear and resolve tax disputes arising from all federal tax legislation. These include the Company Income Tax Act, Personal Income Tax Act, Petroleum Industry Act, Value Added Tax Act, Capital Gain Tax Act, Stamp Duties Act, Tax and Levies Approved List for Collection Act, or regulation or rules issued in terms of this legislation, Finance Act, and any other law subsequently passed by the National Assembly. They are trying to tell us who they are, what Tax Appeal Tribunal actually does. All right. The tribunal operates in 6 geopolitical zones with 8 locations. These are, so they are listing to us now where we can actually find tax appeal tribunal. They also operate in 6 geopolitical zones and they have 8 locations. Appointments and meetings. Appointments and meetings of the tribunal. A chairman for each zone shall be a legal practitioner who has been so qualified to practice for a period of not less than 15 years with consummate experience in tax legislation and tax matter. We are expected to actually understand this appointment or the formation of tax appeal tribunal because you may actually be asked to actually list maybe 5 or 6 of the people that constitute tax appeal tribunal. Don't forget chairman. The chairman must be there and the chairman must be a legal practitioner and must have qualified to practice for a period of not less than 15 years and must have complete experience in tax legislation and tax matter. The chairman shall preside at every sitting of the tribunal, and in his absence, the members shall appoint one of them as chairman. In the situation whereby chairman is not on seat, the other member they will appoint someone to actually be the chairman for that particular meeting. All right. During its meeting, the tribunal shall have the power to conduct its proceeding in a manner it deems fit to ensure speedy dispensation of justice. The hearing of an appeal shall be commenced by the appellant presenting documents and statements which he intends to rely upon, as well as the witness that will call. The respondent or his representative may in like manner present any document or statement he intends to rely upon as well as witnesses he desires to call. At the hearing of an appeal, the tribunal shall admit all relevant evidence, oral or documentary adduced by the appellant or the respondent or any person appealing on their behalf. E. The oral examination of a witness during his evidence is in chief shall be limited to confirming his written of deposition and tendering in evidence all documents or other exhibits referred to in his disposition. Thereafter, after the party may cross-examine the witness who may then be re-examined. When the tribunal deem fit it necessary, it may call upon or, as the case may be, permit any party to produce any additional documents or call additional witnesses or file any affidavit to enable it issue proper direction. This is still trying to tell us the stages in which the tax appeal tribunal actually conduct their exercise. First is that the the first is that the what's it called? They hear from the appellant, that is the taxpayer in this case now. They hear from the respondent, the person they actually um, the tax authority in this case now, and then both of them they will what they will tender their evidence. This is my evidence, so why I need not to be taxed below this amount, certain amount, and then the other party also will table their own evidence. This is also my evidence why this taxpayer need to be taxed be more than this particular amount he actually prefers to be taxed. All right, are we together? Are we together? Hello? Okay, let us continue. We have commissioners. Tax commissioners. Qualification for appointment. A person shall not be qualified for appointment as a tax appeal commissioner unless he is knowledgeable in the law, regulation. Sorry, please. A person shall not be qualified for appointment as a tax appeal commissioner unless he is knowledgeable in the law, regulation, norms, practice, and operation of taxation in Nigeria, as well as persons that have shown capacity in the management of trade or business or a retired public servant in administration. Term of office of tax appeal tribunal. Tax a tax sorry tax appeal commissioner. A tax appeal commissioner shall hold office for a term of 3, renewable for another term of 3 years only and no more from the date on which he assumed his office or until he attained the age of 17. Resignation of or removal of the tax appeal commissioner. A tax appeal commissioner may by notice in writing under his hand address to the minister resign his office, provided that the tax appeal commissioner shall, unless he is permitted by the minister to relinquish his office sooner, continue to hold office until the expiring of 3 months from the date of receipt of such notice. So they are trying to tell us here that a tax appeal commissioner can actually resign from his work if he's not ready to actually get done, if he's not ready to continue the work, if he's not ready to continue the work, he can actually what? He can actually resign. All right, a tax appeal commissioner may be removed from office by the minister on the ground of gross misconduct. If the tax appeal commissioner actually found guilty of gross misconduct, he can be removed. Salary allowance and condition of service of tax appeal commissioner. Salary and allowance payable to and the term and condition of service of the tax appeal commissioner shall be determined by the revenue mobilization allowance and fiscal commission and shall be prescribed in their letter of appointment. Filling up the vacancy of tax appeal commissioner. How do they fill the vacancy? If for any reason other than temporary absence, any vacancy may occurs in the office of the tax appeal commissioner, then the minister shall appoint another person in accordance with the provision of the Act. Constitution of the tribunal. The question as to the validity of the appointment of any person as the tax appeal commissioner shall not be the cause of any litigation in any court of tribunal, and no act or proceeding before the tribunal shall be called into question in any manner on the ground merely for any defect in the constitution of the tribunal. Appointment of secretary to the tribunal. So they also list the appointment of the secretary to the tribunal. Appointment of staff of the tribunal. That is also listed. Jurisdiction of the tax tribunal. So the tax tribunal has the jurisdiction. They have the power to adjudicate or dispute any controversy arising from the following tax law. Number one, they can hear any matter concerning company income tax, personal income tax, petroleum industry act, value-added tax, capital gain tax, and any law contained in or specified in the first schedule to the act. Criminal prosecution, where during its adjudication the tribunal discover evidence of possible criminality, the tribunal shall be obliged to pass such information to the appropriate criminal prosecution authority, such as the office of the Attorney General of the Federation or the Attorney General of the state of any state of the Federation or any relevant law enforcement agency. Appeal to the tribunal. Appeal to the tribunal. A notice of appeal against an assessment shall specify the following particulars. The official number, I think we have talked about this the other time. The official number of the assessment, the date and the year, the amount total profits or on which the tax is charged, the amount of the tax charge, the date of service of the refuser, just as we have actually discussed earlier. Notice of refusal to amend. I think I've explained that also. Appeal from the issue of the service, FIRS. The person aggrieved by an assessment or demand notice made upon him by the service of aggrieved or aggrieved by any action or decision of the service under the provision of the tax law referred to in paragraph 2 and 2.3a above be appealed against such decision or assessment or demand notice within 30 days of the service of notice of assessment. So, okay. Also, number 2, an appeal under this schedule shall be filed within 30 days. It must be filed within 30 days. And 3, where a notice of appeal is not given by appellant as required under the law above within the period specified, the assessment or demand notice shall become final and conclusive. That means the taxpayer, once the taxpayer refuses to object, the assessment has been served upon him within the stipulated time, which is 30 days, it will be assumed that that particular assessment is final and conclusive, and the taxpayer must pay. Appealed by the service. When the service is aggrieved by the non-compliance of a person in respect of any provision of the tax law, it may appeal to the tribunal where the person is resident, giving notice in written through the secretary to the appropriate zone of the tribunal. So the service as well can actually approach the tribunal once they notice that a particular taxpayer is not complying with corporate law and regulation. All right. Procedure before tax appeal tribunal. Procedures before tax appeal tribunal. As often as may be necessary, tax appeal commissioners shall meet to hear appeal in the jurisdiction or zone assigned to that tribunal where a tax Appeal Tribunal has a direct or indirect financial interest in any appeal pending before the tribunal, or where the taxpayer is or was a client of the Tax Appeal Commissioner in his professional capacity, he shall declare such interest to the other Tax Appeal Commissioner and refrain from sitting in any meeting for the hearing of that appeal. This one is just talking about that of independence. Once a particular Tax Appeal Commissioner notices that, oh, this particular client is actually my client, are you getting it like that? Should not actually hear such case. You should transfer that case to another commissioner so as to hear it. Procedures following the decision of the tribunal. Notice of the amount of the tax chargeable under the assessment is determined by the tribunal, as done by the tribunal shall serve by the service upon the taxpayer or upon the person in whose name such taxpayer is chargeable. So once the tribunal actually comes, then they will give a notice of amount to be charged. Based on the evidence they gather together, then they will serve the taxpayer the assessment paid. Appeal to the Federal High Court. So we have talked about appeal to the tax, that is Tax Appeal Tribunal. But if the decision of the Tax Appeal Tribunal is not satisfactory to you, you can actually proceed to the Federal High Court. Can proceed to the Federal High Court. So any person dissatisfied with the decision of the Tax Appeal Tribunal, yes, can actually go to Federal High Court within what? Within 30 days, just as we have it under Tax Appeal Tribunal. Just as we have it under Tax Appeal Tribunal. Also, a notice of appeal shall set out the ground of law on which the appellant case is based. Sorry, please. All right. Number 3, if the service is dissatisfied with the decision of the tribunal, it may appeal against such decision to the Federal High Court. Upon receipt of the notice of appeal, the Secretary of the Tribunal shall cause the notice to be given to the Chief Registrar of the Federal High Court. He, the Chief Judge of the Federal High Court, will take rule providing for the procedure in respect of appeal made under this Act. So we have the right to legal representation. A complainant or appellant may appear in person or authorize one or more legal practitioner or any of its officers to represent him or its case before the tribunal. Power and procedures of the tribunal. The power of the tribunal. A. The tribunal makes rules relating to its procedures. The tribunal shall, for the purpose of discharging its function under Schedule, have power to summon and enforce the attendance of any person and examine him on oath, require the discovery of production of documents, receive evidence or affidavit, call for examination of witnesses or documents, review a decision, dismiss an application for default or deciding matter ex parte, set aside any order of dismissal of any application for default or any other passed by it ex parte, do anything which in the opinion of the tribunal is incidental or auxiliary to its function under the schedule. further appeal to the Court of Appeal or Supreme Court. That is the last place uh, the taxpayer can actually what take their appellation or objection to. A. An appeal against the decision of the Federal High Court at the instance of either party shall lie to the what? To the Court of Appeal. The Supreme Court, yes. An aggrieved party can further challenge the matter at the Supreme Court. So the first instance appeal tribunal, followed by the what? Followed by the Federal High Court. Then if you are still aggrieved, the aggrieved person can actually go to what? Court of Appeal, and from Court of Appeal, you can go to Supreme Court. So once you are not agreed or once you are not satisfied with whatever the Supreme Court says, the next thing is to go to God. It's only God that can now actually come through. Alternative dispute resolution. In Nigeria tax system, alternative dispute resolution (ADR) mechanisms are available to resolve tax disputes efficiently and effectively. The ADR, that is alternative dispute resolution mechanism, include tax appeal tribunal, mediation, that is where a neutral third party facilitates negotiation between what? Between the taxpayer and the tax authority to resolve the dispute. We have arbitration. Arbitration, a process where a neutral third party makes a binding decision on the what? On the dispute. Negotiation, direct negotiation between the taxpayer and the tax authority to resolve the dispute. Fast track state settlement, a mechanism that allows taxpayers to settle tax disputes quickly, usually within 30 days. So those are the alternative dispute resolution. Alternative dispute resolution, we have tax appeal tribunal, we have mediation, we have arbitration, we have negotiation, we have fast track settlement. So procedure for presenting before the tax appeal tribunal. What are the procedure? The first is pre-hearing procedure. First, you file your appeal, you pay a filing fee, service of notice of appeal, then respond to the notice. Hearing procedure, they will fix hearing date, appearance, opening statement, presentation of evidence, cross-examination, closing statement. Then we have what C, which is post-hearing procedure. Judgment, they give their judgment, service of the judgment, then if you are disagree, you appeal again. General requirements, we have representation, we have evidence, and we have conduct. So this is the end of the chapter. We have the chapter review, and you can actually attempt the work example we have here. Thank you for joining and have a nice night rest. Thank you. Good night.